Hi, this is podcast 8 on civil rights. Last time I talked about civil liberties. These are the things that we want to protect, what government can do to individuals. But as I said before, civil rights is different. We want to protect ourselves by telling the government that they must treat everyone equally under the law, especially those groups that in the past haven't been treated equally under the law. Now keep in mind that this is based on the 14th Amendment, which we didn't have in the Constitution for the first 100 years or so of our nation's history. It was only ratified in 1868, after the Civil War. And of course, it wasn't until 100 years after that, during the Civil Rights Movement, that we really got the whole country on board with allowing everyone to vote, especially blacks in the South, and making sure they had equal protection. It's a struggle we still have to deal with today, but it really took a couple centuries for this to happen. So the story of much of our country's history has been around those groups that got left behind in the original drafting of the Constitution. And that's pretty much everyone, unless you're a white male with property, right? Because that's who they were talking about when they originally drafted the Constitution. But everybody else has had to fight at some point for equality. It's a great struggle, and I think it's improved us as a country, but it's a very difficult one. And of course, people have been hurt along the way in that struggle. After the Civil War, as you know, the South did not want to go along with this new idea of civil rights, especially allowing blacks to vote and to be on an equal par with whites. And so hundreds of segregationist laws, if not thousands, were passed to prevent blacks from obtaining those same rights in the Jim Crow South. Some of the most important civil rights cases you probably already know about from high school history class, but I'll go over a couple here as a reminder, and you should pay attention to some of the many cases that are mentioned in your book. I don't have time to go through all of them. But one important case was Plessy versus Ferguson, decided in 1896. There was a Louisiana law that had been passed that prohibited whites and blacks from riding in the same railroad car. And there was an African-American man, he was actually 1/8 African-American, but he was named Homer Plessy. He challenged the law by sitting in a whites-only rail car. And he maintained that the 14th Amendment's Equal Protection Clause protected him from discrimination on the train. The Supreme Court, however, actually sided with Louisiana, saying that as long as facilities for whites and blacks were relatively equal, then you could mandate separate facilities for different groups. This is what's known as the separate but equal doctrine. And it really opened the door for many other states, not just Louisiana, to engage in a wide range of what ended up being legalized segregation. And it really wasn't until 1954, so they had to wait another 60 years in court history, in the Brown versus Board of Education of Topeka, that the Supreme Court reversed itself by ruling that the separate but equal doctrine that had previously justified segregation in public schools was unconstitutional. And it is something, a tribute, I guess, to the institution of the court. You may disagree with it at lots of different times, and you may believe that it's way too slow to act. Certainly, 60 years of segregation would support that. But you can say that the court is capable of reversing itself when it has decided it made the wrong decision. That, at least, we've given the Supreme Court enough latitude to do that. I think that's a good thing. So the Plessy versus Ferguson case did demonstrate that there could be a lot of disagreement on the court and in the country itself about what this phrase equal protection should mean for all these groups of Americans that before this we had seen as unequal. So what tools does the court use to figure out all of the balancing interests when a case comes up on civil rights? When is it okay to maybe restrict equal protection, or is it ever okay? Well, there are three tests that judges use that your book mentions when they're faced with making a decision about constitutionality of a particular law when it comes to civil rights. We have the rational basis test, the intermediate test, and the strict scrutiny test. That's kind of hard to say very fast. And these tests, as I said, are used to determine the type of unequal treatment at issue. The rational basis test is the lowest level of scrutiny that a court can use to determine if a law is discriminatory and violates the Equal Protection Clause. Under this test, the discrimination must simply serve a reasonable purpose for the law to be valid. So, for example, you might, with the rational basis test, decide that differences in age or appearance, ability, sexual orientation, or economic standing might actually fit under that test. For example, we do discriminate against anyone under 16 in the sense that they can't get a driver's license, but we all agree that there's a reasonable purpose for not having an 11-year-old behind the wheel. The strict scrutiny test is the highest level of scrutiny that a court uses, and this means that if we're going to permit unequal treatment, the government must prove that a law or a practice is narrowly tailored and it serves a compelling state interest. Usually this test is used when the group being discriminated against is part of what's called a suspect classification, kind of a strange legal term, but this just means that a suspect classification is a group that as a whole has traditionally faced discrimination and prejudice. And so these would be African Americans, for example, and immigrants, all sorts of people who in the past have faced discrimination. So unequal treatment of citizens based on race, ethnicity, country of origin is usually subject to the strict scrutiny test, and it's the toughest test. All right. Very few discriminatory laws pass this strict scrutiny test, while there are a lot of laws that can be justified under the rational basis test. But one of the most compelling civil rights movements that we're all living through right now is the decision we're making as a country on whether the LGBT community falls under a suspect classification, and can they be protected under some of the tests that I mentioned before, and specifically the strict scrutiny test. So in terms of the gay community, courts have been hesitant in the past to treat this group as a suspect class, because if you do so, you would require that all state-based discrimination against gays be eliminated unless the discrimination serves a compelling reason or there's a compelling state interest. But of course, most laws that discriminate against gay folks, and there are quite a few states that still have laws that ban gay marriage. California is not one of them anymore, though we did have one, Proposition 8. But those laws are based on the state's view of morality and its rationales about promoting family or public health and safety. They would maintain that in these laws that say, for instance, gays cannot obtain a marriage license, well, it's necessary to protect the morals of the people and to, as I said, there are compelling health and safety interests. Now, a lot of people see these as weak arguments to justify discrimination against a whole group of people, yet sometimes these arguments may be enough for some courts under the rational basis test. So this is why I'm telling you about these tests. It's really important to know which test which judge is using on a particular case. That will give you a hint as to the outcome. My thought is that now that the Supreme Court has struck down the prohibition against same-sex marriage that was written into federal law, that was called the Defense of Marriage Act, that that made a lot of headway, and I think it's only a matter of time. And for some, that may be too long a time that state law cases will be, or I should say state laws will be challenged and make their way up the chain to the Supreme Court to see if they are discriminatory or not. And they'll be using these tests that you're learning about. So I think if you're interested in this issue, it's worth learning something about the legal doctrine. Okay, something to ponder here at the end, which is your book goes through each group that in the past has suffered discrimination and talks a little bit about them. But one interesting thing to note is that most minorities, these people who fall into suspect classes, overwhelmingly vote for Democrats when it comes time to vote in elections. And you might want to ask yourself, well, why is that? In the past, Democrats have traditionally been supporters of civil rights causes. Things like affirmative action, which has fallen quite into a bit of disfavor now, but in the past has allowed more opportunities for minorities. But the fact for the Republicans is that they need many of these voters to win in future elections, in particular Latinos. You might want to note in that section on Latinos that they are the largest minority group in the country. They're growing by 1 million a year. And they are a very important block in public opinion and voting. So I guess the question you should ask yourself is, how could the Republican Party change their stance on particular civil rights issues in order to get some of these folks to vote for them? And I'm not just talking about immigration. That's the easy one. But there are other civil rights issues mentioned in this chapter that I think the Republicans could make headway on if they actually made an effort, and it might be in their political interest to do so. Thanks, and I'll see you next time.